Alright, Assalamualaikum warahmatullahi wabarakatuh. This is the copyright part 2 on authorship and ownership. Right. So we have discussed what are the categories of the copyright. We have also discussed on the factors for work to be protected in Malaysia. So now we are discussing on who is the author and who is the owner of the copyright. Whether the author and the owner is the same person, or can the author and the owner of the copyright constitute different person. Okay, so this is the structure of the presentation. Introduction, literary, musical and artistic work, films, sound recordings and broadcasts, as well as the joint authorship. Okay, what are the requirements for a work to be considered as joint authorship? Okay, the general principle for a work, for the authorship of the work is the person who creates the work is the author. Okay, anyone who created the work is the author. For example, this invention is created, this work is created by Isham, then Isham is the author. That is the general principle, and this is also the principle that had been referred to by the court in the case of Goya Tire and Rubber Company, and another with Silverstone Tire and Rubber Company. I think someone has already presented this case. Okay, what happened in this case is Goodyear Tire claim, okay, plaintiff is the Goodyear Tire. They claim that they are the owner they are the copyright owner of the Aquatrack. Okay, remember about the Aquatrack tire. Okay, so they are the owner of the drawings of this Aquatrack tire. Okay, but so they apply for the interlocutory injunction to with the court, okay, to stop Silverstone from continue manufacturing the same types of tire. Okay, so the court said that, okay, you claim that you are the owner, so how do you prove that you are actually the owner? But in this case, the plaintiff failed to prove who is the owner. They failed to bring to the court the author of the drawing. So since they failed to bring to the court the author of the drawing, so court said that then you cannot prove you are the owner. So you are not the owner of the drawing of the Aquatrack tire. Right. Next is the who is the owner or who is the author of the literary, musical and artistic work. Okay. A for the literary works. Okay, section 3 mentions that the writer or the maker of the work is the author. Whoever who write or whoever who make the work is the author. Okay, sekarang we are talking about the authorship of the work. So if you want to know who is the writer or the maker, if you want to know who is the author of the work, then it belongs to the writer or the maker. However, the person who records the work is also the maker, provided that he has given additional specific contribution. Okay, even though you are only the recorder, but if you have given additional specific contribution, if you have already contributed to that work, then you are also considered the maker. When you are considered the maker, then you are also the author. Okay, so that's the analogy. Okay, for example, Ali said that Ali recording my whatever I'm lecturing right now. So he record the work, like converting the slide notes into the converting the slide notes into the into a module, or converting the slide notes into a mind map. So he has already given additional specific contribution. Then Ali is also the maker of the work. When Ali is the maker of the work, then he is considered as the author. Okay, in the case of Robin Ray and Classic FM, in this case, the court held that the person who takes down the narrated text, okay, taking down the narrated text is not the author. Why the person taking down the narrated text is not the author? Because that particular person did not provide any additional specific contribution. Okay, dia take down je, they only copied everything that had been said, so they only write it down. Can they register themselves as the author? No, they cannot, because they did not provide any specific contribution. Okay, however, in the case of Walton and Lane, so this is where additional specific contribution played its role. Okay, what happened in this case is that the court held the reporter who took shorthand notes, okay, from a speech. Okay, there is this reporter, they took a shorthand note from a speech, and then from that particular speech, she made several amendments, revision and amendments, and then give it back to the speaker to check. After that, they claim that the notes belong to the reporter. So the court held that, okay, the act of revision, the act of doing the amendments, okay, is actually specific contribution done by the reporter. So the reporter is also the maker. Okay, next is musical works. Okay, Section 3 define author is the composer. Whoever is the composer of the work is also the author of the work. Okay, in the case of, under Oxford Dictionary, composer is defined as a person who writes a music. Okay, however, what about if there is a musical accompaniment is written by another person as background music? So is there separate ownership or separate authorship, or it is considered as one authorship? Okay, refer to this issue whether there is a single musical copyright in the resulting work, or whether a separate musical copyright attached to the author of musical instrument. Ada satu single musical copyright ke ada separate musical copyright? Okay, so what happened in the case of Rock Records syndrome and One Entertainment Berhad ialah is that there is this licensing agreement. Okay, licensing agreement entered into by the plaintiff and the defendant. So in the single musical instrument, there is also sound recording of several other sounds. So is there only one master tapes authorship, ataupun or in each of every sound recordings yang being accompanied with the musical instrument also can have their own authorship, in which court held that the instrument, okay, the musical tapes here has one authorship, okay, and each of these sounds that is embedded in the master tape also have their own authorship, meaning to say that there are two authorship lah. Okay, next is artistic. Okay, in relation to artistic work other than photograph means the artist. Okay, if it is involve artistic work, any artistic work, so who is the author? The author is the one who is the artist. Meaning, if it involve a painting, then the painter is the artist. However, it's not the same case with the photograph. Okay, if for example I took a photograph of Arif. Okay, I took a photograph of Arif. So who is the author? The author is me, not Arif. Even though Arif picture is in that particular photo. Okay, because if it is in relation to photograph, means the person by whom the arrangement for the taking of the photograph been taken. So the one who take the photograph, meaning the photographer is the owner of the photograph, not the person in that photograph. Okay. In the case of Sharina Nur Alina ni, okay, Sharina Nur Alina is actually a Ratu Cantik. Okay, so she won several competitions. So her picture has been pasted in several products. So she claimed that the owner of that particular picture is hers, but the court held that no, it's not yours. It's owned by the photographer. Okay, next is film, sound recording, broadcast. Okay, in which it is divided into film, sound recording, and broadcast. Okay, who is the author for the film and sound recording? Section 3 defines any person, okay, the person by whom the arrangement for the making of the film or recording were undertaken. Whoever had made the arrangement for that particular film or for that particular recording. Normally we refer to the producer lah, okay. We refer to the producer. Okay, emphasis In the case of road records and audio one entertainment, the court gave emphasis on the person who makes the arrangement. Okay, emphasis is given to the person who makes the arrangement. Whereby, in the case of, in this case, road record, the court held that the author, okay, the author of, okay, the court held the author of sound recording belong to the record company. Belong to the record company. Okay, kenapa dia belong to the, why the author of the sound recorder belong to the record company? Because this record company is the one who making the arrangement for the recording to take place. Okay, right, so that is the ratio descendandi in the case of records. Okay, can the authors also refer to body corporate? Okay, can the authors also refer to body corporate? Okay, in the creative purpose in the Berhad, okay, what happened in this case? The court held that, the court said, okay, if you refer to the definition of qualified person, okay, remember, factors for a work to be protected in Malaysia, there must be a qualified person. So the definition of the qualified person is defined under section 3 of the Copyright Act, in which qualified person is defined as the citizen, okay, citizen of Malaysia or body corporate established in Malaysia. Okay, so in this case, the argument is that since body corporate also is defined as qualified person, so why is it impossible for the authors to refer to the body corporate? Okay, that's why in this case court held that yes, body corporate also can be the author. Okay, next is the broadcasting. Alright, for the broadcasting, section 3 mentions that in relation to broadcast transmitted from within any country, who is the author? The person transmitting the program, if he has responsibility for the selection of its content, or any person providing the program who makes with the person transmitting it the arrangement necessary for its transmission, meaning anyone who has the responsibility for the selection of the program, or the one who makes the arrangement. So that is the author. In the case of MediaCorp and MediaBank, plaintiff, okay, plaintiff here, MediaCorp is a broadcasting company from Singapore. Okay, broadcasting company from Singapore. So issue in this case is who is the author of the work. So the court held that the author of the work was the producer, okay, producer of the broadcast. Okay, now moving on to the joint authorship. Okay, section 3 provides that a work produced by the collaboration of two or more authors in which the contribution of each author is not separable. Okay, joint authorship ni, what is this joint authorship? Joint authorship ni is the collaboration of two or more authors. It must be more than one author, and their contribution cannot be separated. So those are the definitions of the joint authorship under section 3. So the requirement for the joint authorship to take place is that first, collaboration of two or more authors. Second, the contribution cannot be separated. For example, A and B write down a book. Okay, so both of them working together to write a book. A mentions that from chapter 1 to chapter 3 is his contribution, while B said that chapter 4 to chapter 6 is his contribution. Okay, since the contribution is separable, okay, so it cannot be considered as joint authorship. When A and B didn't know which part of the book that they have already contributed, only then it can be considered as joint authorship. So it must be shown that each author has expended skill and sufficient effort in order to make the contribution original in character. So whatever it is, you have to go back to the general principle, to the basic principle of the copyright, which is in order for a work to be protected in the copyright, it must be original. Okay, dia mestilah original. Okay, so macam mana, how do we want to know that the work is original? There must be sufficient effort. Okay, there must be sufficient effort. Okay, sufficient effort. Okay, how do we know that the sufficient effort has been expended? Dia ada 3 elemen dia. So it must be sufficient effort. There must be some effort, skills and judgment. Okay, judgment or labor or time. Okay, so these 3 requirements must be fulfilled to be considered as sufficient effort. Okay, so only then the work can be protected as under copyright. Okay, if there is no effort or if there is no skills, then the work does not have sufficient effort. When it does not have sufficient effort, then it's not original. When it's not original, then it cannot be protected under copyright. Okay, so what is the differences between the ownership and authorship? Okay, can the owner and the author of the work is of different people or not? Right. Section 26 provides that copyright conferred by Section 10. Okay, in under Section 10, this can be referred to factors for a work to be protected in Malaysia. Okay, in Malaysia. Okay, in which Section 10 Clause 1 mentions that you must be a qualified person. Qualified person must be citizen or body corporate established in Malaysia. The work must be made in Malaysia. The work must be published in Malaysia. So that particular work shall vest, the ownership of the work shall belong to the author. However, under the same section, there are 2 exception. Ada 2 pengecualian. Okay, in which if the work is a commission work or it is made in the course of employment. Okay, kalau dia, if that particular person is being paid to do that particular painting. So, for example, A being paid by B to draw this painting. Okay, so who is the owner of the work? It is B. Why? Because the ownership has been transferred to whom? To the person who paid for the commission. So B is the one who paid for the commission. So that's why the ownership of the work belong to B. Okay. The same case also in the course of employment. If the work is done within the course of employment, so who is the author of the work? It is the employer. Okay, employer, because the ownership of the work has been transferred to the employer. Okay, how do we determine the relationship between employer and employee? Alright, macam mana kita nak determine if there is a written contract? Normally, the relationship of the employer and employee is laid down in the contract of employment. So that's why later on when you work, make sure that you read carefully. You read your employment contract carefully. Okay, so what about if there is no, if it is in the absence of written contract, there is no contract between the employer and employee, then you have to look at the nature of the work. Okay, you have to look at the nature of the work in order to determine your relationship. Okay, how do we know that that person is an employee or not? Okay, how do we know that that person is an employee or not? Okay, in the case of McNawi just now, okay, in the case of McNawi, the one who draw that particular drawing is the managing director, is the managing director of McNawi. So defendant argued that since this person is the MD, managing director, then he's not the employee. Court held that, why are you saying so? Because MD also can be considered as employee. That is in the case of McNawi. Another case is Hexagon Tower. So what happened in that case is about the tumbler. So plaintiff tumbler has been drawn by the general manager. And then the general manager later on be appointed as the executive director. So defendant argued that being the executive director, he's not the general manager, is not the employee. So since it's not the employee, then the drawing should not belong to the company lah. That's the argument from the defendant. However, the court held that since plaintiff has successfully proven
there is this EPF statement as well as job description, that it is within the job description of the executive director to do that particular drawing. So that's why in that case, court decided in favor of court decided in favor of the Astaghfirullahalazim, court decided in favor of the plaintiff. Okay. Now, work made in the course of employment. So, in order for a work to be transferred to the employee, the work must be made in the course of employment. Dia mestilah yang relevant to the employment. Okay, relevant to the one that you have been employed. For example, I'm a lecturer in UTM. So, in my JD, what I have to do is giving lecture, writing a book, getting client, writing articles, publish article, so and so. So those are the things within my job description. So it is in the course of employment. So anything that I do within my course of employment should belong to the UTM, because UTM is my employer. However, for example, I'm being hired to give lecture, to write a book, etc., etc. So what if I went and open a kedai dobi, or I open a restaurant? Okay, so for example, I want to trademark the name of the restaurant. So the trademark, should it belong to UTM, or should it belong to me? So it should belong to me, because opening a restaurant is not part of my JD as a lecturer in UTM. Okay, so those are the differences between the work made in the course of employment, or the work made is not within the course of employment. So only work that has been made in the course of employment can be transferred to the employer. If it's not made in the course of employment, then it cannot be transferred to the employer. Okay. So issue whether the skill and effort exerted in the creation of work are part of the employee normal duty or not. Okay, is it part of the normal duty ataupun tidak? Okay, for example, in the case of Stephenson Jordan and Harrison Limited and McDonald, what happened in this case is there is this accountant employed by the plaintiff to deliver some lecture. Okay, plaintiff, they employ this accountant to deliver a lecture. Alright, so which the accountant later on converted the lecture into a book. So the court held that the copyright of the book belonged to the accountant, okay, not to the plaintiff. Why? Because plaintiff employed the accountant to give advice on the accountancy basis, not on giving the lecture to be an accountant. So the plaintiff cannot later on claim that, okay, so since you do this within your course, when you are employed with me, then everything that you do should belong to me. No, it's not the principle. So only the work, or only the matter that is done within the course of employment can be protected, can be transferred to the employer. If not, it cannot be transferred to the employer. So whether the work was made during normal working hour, this is the these are among the issues that you can discuss in order to determine whether the work is done within the course of employment ataupun tidak lah. We look at whether it is the normal duty ataupun whether it is during the normal working hour. For example, here a journalist who is employed by a newspaper writes an article during office hour to be published in the newspaper. First, it is a journalist. Okay, so it is her job to write down to write an article, and it is done within dia punya office hour. So obviously the work shall be transferred, the ownership shall be transferred to the employer. Okay, how do you want to prove ownership of the copyright? Okay, so proving the ownership of the copyright, even though there is no need for you to register your copyright in MyPo, it is not mandatory for you to go to the MyPo and register your copyright. Okay, because the principle of the copyright, as long as you have the idea, you protect the idea, okay, and then you are the copyright owner. But if you want to sue someone saying that that particular someone has already infringed your work, how do you want to prove that you are actually the owner? So actually our Copyright Act and MyPu has working on some documentation um, in order to ease the difficulties by the copyright owners, okay, on how to prove their ownership. First is by way of affidavit or statutory declaration. Statutory declaration ni akuan kanun bersumpah, akuan sumpah berkanun. Macam for example, if you took a JPA scholarship or if you took a PTPTN loan, I think there is this one document that you have to go to the Pesuruhjaya Sumpah or Commissioner of Oath, confirming that yes, you are this person and person apa semua, okay, Pesuruhjaya Sumpah tu, so that the document that had been stamped by Pesuruhjaya Sumpah or Commissioner of Oath, itu yang kita panggil, that's what we call as statutory declaration. Okay, itu satu. And second, how do you want to prove your ownership is by way of registering your copyright. Okay, registering of copyright ni where? Dekat MyIPO. Okay. Right. Okay, first affidavit of statutory declaration. Okay, section 42 provides that an affidavit or statutory declaration made before any person having authority to administer oath. Okay, this any person having authority to administer oath ni kita panggil, we call them as a commissioner of oath. Okay, inilah dia commissioner of oath or Pesuruhjaya Sumpah. Okay, only any person who has been licensed as Pesuruhjaya Sumpah can stamp the statutory declaration. If you go to someone else yang I don't know who, just ask someone. For example, you come to me and ask me to stamp your document, no, it is not valid. The statutory declaration is not valid. Okay, the owner of the copyright in any works eligible for copyright under this act, stating that the time specified here in copyright, who is the person, who is the owner, who is the author, and you have to attach together with the original copy of the copyright. Okay, in the statutory declaration. Okay, statutory declaration is actually a document. Okay, so in this statutory declaration, you have to mention when, the date of the completion. Okay, when do you complete this work? Okay, so you have to, for example, January 2021. So who is the author? Author is A. Who is the owner? Owner is B. Because even though A is the author, for example, even though the work is done by me, but since I have been employed by UTM, so the work has been transferred to UTM. Okay, and you have to attach together with the document. Right. Okay, what about the performer? So if it is in the case of performer, if it is a performance eligible for performance right under this act, stating that the time you have to specify when do the performer perform that particular performance, or who is the person who is the performer, and you have to attach together with the document which prove that you are actually the name perform in the performance lah. Maksudnya, for example, you attach together with your perhaps the NRIC ke, or you have to attach together with the appointment letter or any document yang prove that you are actually the performer. So those documents, DSD, shall be admissible in evidence, okay, as prima facie evidence in the court. Okay, prima facie evidence means evidence yang utama. Prima facie evidence. So it is actually accepted evidence in the court it is actually an accepted evidence in the court lah. Okay. In the case of PP and SIM Audita Muhammad Architect, so this case is a criminal case. Why is it criminal? Because PP here, public prosecutor. So bila dia guna, when the case is being brought by the public prosecutor, meaning this particular accused had been charged under offences under section 41 of the Copyright Act. Okay, offences provided under section 41 of the Copyright Act. Okay, what happened in this case ialah PP claim that PP bring the statutory declaration. Okay, saying that who is the original owner of the work. However, in that statutory declaration, the person who stamped the SD is not a licensed commissioner of oath. That particular person do not have the authority to stamp the SD. So due to that, the SD has been rejected by the court. Next is just now I mentioned that statutory declaration is considered as prima facie evidence. So can it be rebutted or not? Okay. Kalau kata dia prima facie evidence, then you cannot reject the evidence anymore ke? Okay. So the answer is yes. The answer is no. Even though it is a prima facie evidence, it still can be rebutted. Okay, boleh di-rebut lagi. For example, in the case of Microsoft Corporation and Yong Wai Hong, right. So in this case, court said that okay, if you want, it was for the defendant. Okay, defendant is the one who need to bring the positive evidence. Okay, who need to bring the positive evidence in order to rebut the prima facie evidence. For example, A said that okay, the owner of the copyright is Amina. Okay, A said that the owner of the copyright is Amina. Then defendants said no, it's not Amina. The owner of the work is actually Amin. Okay, the owner of the work is actually Amin. So defendant claiming that Amin is the original owner must bring the evidence to the court lah. Perhaps defendant can bring the another statutory declaration or can bring Amin as the witness of the case. Okay, so it is the responsibility of the defendant to bring the case to the court, to bring the evidence to the court. Okay, another case is Lamsun. Lamsun and Forward Supreme. Okay, what happened in the case of Lamsun ialah, okay, sama je. Sama, case SD juga. Okay, statutory declaration. So, Lamsun, dia bring a statutory declaration saying that they are the owner of the Lamsun knife label. Okay, dia punya work ialah Lamsun knife label. So, Lamsun bring the statutory declaration that claiming that they are the owner of this work. Okay, so they claim that they have already paid for a commission. Okay, paid for a commission, has commissioned someone to do this label. Okay, in 1982. Okay, however, defendant said that okay, how on earth do you pay someone to do this in 1982? Sebab, why? Because in 1982 you are a dormant company. Dormant company. Okay, since you are a dormant company and only become active in 1985, so it is not possible for you to hire someone to do this label in 1982, and these facts has not been rejected by plaintiff. So in this case, the court reject the SD. Okay, right. Affidavit, next is the affidavit or SD does not automatically become proof of those facts, become proof of the fact that you are actually the owner. Okay, in the case of Ulster Metering Limited and another, okay, what happened ialah first plaintiff, they claim that they own a copyright in the water meter drawing. Okay, water meter drawing. So plaintiff claimed that they are the owner of the copyright by providing the statutory declaration. Okay, but when the court look at the statutory declaration, there are a lot of flaws in the statutory declaration. For example, there is no specific time. They also did not write down who is the author. They also did not attach together the original drawing, and due to that, the court had rejected the statutory declaration. Okay, next is the registration of the copyright. Okay, so there are two ways on how do you want to prove your ownership. First is by providing the affidavit or statutory declaration, and second is by way of registering of the copyright. Okay, there is this additional provisions being included in the Copyright Act in which notification of copyright is accepted as the prima facie evidence. So, inilah dia the notification, notice pemberitahuan sukarela, voluntary notification. Okay, so this notice said that sukacita dimaklumkan bahawa hak cipta your work has been protected under copyright. So they lay down they list down what is the topic is all about, who are the author. Okay, and this one, if you want to get this letter, you have to file CR1. This is the name of the form. You have to file CR1 together, attach together with the statutory declaration, and then you have to attach together with the original work. Okay, you have to attach these three and pay certain fee, pay the fee, then you can get this letter. Okay, that is one. Second is, together with this letter, normally they will attach a CR5 form. Okay, CR5 ni is actually a form asking, do you want some certificate? If you said yes, fill in this form. This form has already been filled in actually, and then pay certain fee, RM50 ringgit. Then within 1 or 2 months you will get this certificate. Okay, so those are the procedure on how to register your copyright. So the registration system, we call it as the voluntary notification system. Right. What is a voluntary notification? General principle, there is no formality requirement for the copyright. Okay, like I said just now, you have the idea, you express the idea, then you are the copyright owner. There is no need for you to go to the MyPo and register your copyright. Okay, because copyright protection is automatic. Okay, the copyright protection is automatic, but how do you want to prove your ownership? So that's why MyPo takes the initiative to introduce this voluntary notification system. So what is the purpose of this voluntary notification? First is to support and assist copyright to prove your ownership. Second is serve as prima facie evidence in the court. And it is for the database for research and education. For the research university, we have to report to MyRA every year. We have to be audited by MyRA every year, and it serves as the database. So for RU, it's no longer voluntary. It's obligatory in nature for RU, for the research university. Okay, if not, if you only provide the statutory declaration during the audit process, your evidence will be rejected. You have to register the voluntary notification. Okay, now moving on to the dealings and durations of the copyright. Okay, and I will record these dealings and durations in another recording. Okay, thank you.